Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And I have been promising you guys that I was going to do a video on double jeopardy because a lot of people keep saying that because Mr. Kelly was brought up on charges in Chicago back in 2008, that it's double jeopardy for the federal government to try him in Illinois for those same charges or for that same videotape. And I had done some research on this a while ago and discovered that double jeopardy doesn't cross from state to federal cases. And so it wouldn't apply in this case. So the federal government can very well bring charges against him in federal court that he faced in state court. Excuse me. You guys know when I get to talking, my voice get to acting up on me. So anyway, I found this website and it's called fija.org. And it has a library of information on court cases and how the court system works. And so I'm just basically going to bring you this information. It starts out, and then following this, there was a Supreme Court ruling that came out this week concerning double jeopardy that I am also going to talk about once I finish sharing with you what they have on this website. So it starts out with, what is double jeopardy? The most basic understanding of double jeopardy is that it refers to prosecuting a person more than once for the same offense. Double jeopardy is prohibited by the Fifth Amendment to the United States Constitution, which reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." So guys, hold on for a second and go get some water. Okay, for those of you who are new to my channel, I've been going through it with my voice, especially last night. I did that video that was over 2 hours long, so there's some strain going on here with my vocal cords and all. And then I have issues like when it rains and that type of stuff. So if you hear my voice getting raspy and going out, that's why. So continuing on, so that is what the Fifth Amendment states. So many states have codified a similar prohibition on double jeopardy into their constitutions. However, even those that have not done so are bound by this clause of the Fifth Amendment, which the Supreme Court has ruled also applies to the states. The court held in Benton versus Maryland, which is a case from 1969, that the double jeopardy prohibition of the Fifth Amendment, a fundamental idea in our constitutional heritage, is enforceable against the states through the 14th Amendment. Legally speaking, the concept is somewhat narrow than this simple explanation alone might suggest to those of us who are not deeply involved in the legal profession. And that would be moi, okay? When I earned my college degrees, they were not in law, okay? So bear with me. That's why I have to research and find these articles to bring to y'all to try and help explain some of this stuff. So for instance, if you are convicted of car theft, the prohibition on double jeopardy does not mean you can't be prosecuted in the future for theft of another car. It does not mean you cannot be prosecuted for another instance of theft of the same car again in the future. It does not mean that you cannot be prosecuted for violating additional laws at the same time as a result of the exact same actions that put you in violation of the law against car theft. So for example, say you steal 2 cars on the same night, and you get arrested for stealing the first car, and you're found, well, whether you're found guilty or not guilty, it doesn't matter, but you're arrested and charged for stealing a red Camaro. And then 6 months later, they do some DNA testing or whatever and find out that you were the person that also stole a blue Corvette on that same night. Just because you were arrested for stealing the red car on June 18th, 2000, doesn't mean that you can't be prosecuted for stealing the blue Corvette on that same night an hour later. So maybe if you had been arrested for stealing both cars, you would have faced 2 counts of auto theft, right? And so you can't turn around and say, okay, well, you already found me guilty, I'm serving 5 years, so now it's double jeopardy to turn around and charge me for that same car because it happened in the same night. Or in the instance where, say you steal a car and then you hit somebody and leave the scene. So it's not double jeopardy to arrest you for stealing the car and putting you on trial, and then later finding out that you were the person that was driving the car that hit the pedestrian who was killed in the hit and run. They can still go back and charge you for that hit and run, even though you've already gone to trial for stealing the car. Okay, so then it says, once you are acquitted or convicted of a specific instance of violating the law against car theft, however, you cannot be prosecuted or punished again if convicted on that same charge by the same government for that same instance of violating that law. And so basically what that means is you stole the car, you were arrested, but they didn't have enough information to charge you. And so the charges were dropped, or maybe not dropped. You went to court and you were found not guilty. And then later on, they get an eyewitness who say that they saw you steal the car. They can't then come back and charge you again for stealing that same car if you've already gone through prosecution for that car, for that same car theft. Okay, so then they move into, when does jeopardy attach and what does that mean? So many of us are familiar with the constitutional prohibition on double jeopardy codified in the Fifth Amendment. We may be perplexed then when we see someone being tried more than once for the same offense. Isn't this putting them in double jeopardy? So the answer to that question is somewhat less than straightforward to the average person, given the way courts have interpreted the particular clause. Let me take that cough drop out. Given the way courts have interpreted this particular clause of the Fifth Amendment, one of the boundaries that courts have established that limits our constitutional protection against twice being put in jeopardy of life or limb is the concept of attachment. When jeopardy is said to attach, is the first time in a legal proceeding at which courts legally recognize the accused has been put in jeopardy of life or limb as intended by the Fifth Amendment. We might consider ourselves in jeopardy of life and limb when a police officer points a gun points a gun at or shoots us, tasers us, tackles us, and pins us painfully to the ground with a boot on our back, handcuffs us, and imprisons us, etc. None of those things, however, are considered in the American legal system to put us in jeopardy for purposes of the Fifth Amendment prohibition against double jeopardy. Neither does being indicted or charged put us in such jeopardy according to the courts. Neither does being held in pretrial detention without bond. Neither does being brought into pretrial hearings or even selecting a jury start the clock, so to speak, on jeopardy. Jeopardy attaches at different times depending on what route a case takes through the legal system: trial by jury, bench trial, plea bargain, or juvenile proceeding. In a trial by jury, the rule is that jeopardy attaches when a trial jury is sworn. So in Downham versus United States, which was a case heard in 1963, the United States Supreme Court ruled against a second prosecution of a defendant whose trial ended immediately after the jury had been sworn, even though both sides said that they were ready to proceed at the start of the trial. After the jury was selected and sworn, the prosecutor announced that a key witness was not present. The judge discharged the jury and the case was called again 2 days later, at which time the defendant argued that this was double jeopardy, and the Supreme Court agreed. Further, in Chris versus Bretts, a case from 1978, the court held that the federal rule that jeopardy attaches when the jury is impaneled and sworn is an integral part of the constitutional guarantee against double jeopardy. In Martinez versus Illinois, a case that was heard in 2014, the court again reiterated this rule, stating that the Illinois Supreme Court's error was consequential, for it introduced confusion into what we have consistently treated as a bright line rule. A jury trial begins and jeopardy attaches when the jury is sworn in. The rule applies to trial by jury in all courts in the United States and not just federal courts. As legal theory and practice continue to evolve, there are some gray areas in jurisprudence as regards the attachment of jeopardy. For instance, some courts have held that if someone is tried in a court that lacks jurisdiction over them, then jeopardy never attached, even if a jury was sworn. Because jeopardy never attached, retrial of the individual in a court with proper jurisdiction would not necessarily be barred. Jeopardy may also be considered by some courts as having not been attached in a trial where an acquittal has been achieved through fraud or collusion. Situations like these are common exceptions to the rule. So they're saying that, double jeopardy comes into play once the jury has been sworn in. It doesn't matter if the trial ever starts or not. Double jeopardy is now available as something to the defendant in the event that the government tries to come back and try them again. And then they give these other instances, where it comes into questions such as the person, say the person committed a crime in one county but then was arrested in another county, and they're trying to charge that person in that county. Different things and technicalities that can happen to cause double jeopardy to come into play. And so then they go on to the next question. So when does jeopardy terminate, and what does that mean? So jeopardy is said to terminate at the point during a legal proceeding at which a person is no longer legally considered to be in jeopardy after jeopardy had initially attached. When jeopardy terminates in a legal proceeding depends upon how that proceeding unfolds. In a trial by jury, after jeopardy attaches, jeopardy terminates when a jury explicitly finds the defendant not guilty, a jury implicitly acquits someone of a greater charge by finding them not guilty of a lesser charge, and returning no verdict on the greater charge. So say you were charged with murder in the first degree and also manslaughter. So they find you guilty of manslaughter, but not of murder in the first degree. The government can't come back and retry you for murder in the first degree. So a judge grants a dismissal for insufficient evidence, and then they have usually in parentheses. So you don't get to come back and retry the person because you didn't have enough evidence in the first place. And in some cases of mistrial, but not a mistrial due to a hung jury, or when an appeals court reverses a conviction based on insufficient evidence. So once the appeals court has spoken, you can't come back and try the person again. And then where they talk about a hung jury, so I think you can be retried on a hung jury. I've seen that happen before. But if a mistrial happens, say in some cases of mistrial, but not a mistrial due to hung jury. So I guess for other reasons of a mistrial, they might be able to come back and retry you, but they can't if there's a hung jury. Or is it the other way around? Let's see, in the trial by jury, after jury attaches, jeopardy terminates. Terminates in some cases of mistrial, but not a hung jury. Okay, so yeah, that's right. Okay, so it is not when jeopardy attaches that the prohibition against double jeopardy takes effect. While a person is considered to be in legal jeopardy, many things can derail a trial in progress and result in a do-over for the prosecution. It is not until jeopardy terminates that the prohibition against double jeopardy and the protection thereof takes effect. So yeah, so that would be like if the judge declares a mistrial because, some like they had agreed before the trial started that either the defense or the prosecution couldn't enter certain evidence or question certain people, or they do something that the judge had ruled they couldn't do during the trial, and then one of the parties does that, and the judge declares a mistrial. That doesn't mean that they can't retry you. It just means that there's a mistrial. There's something that happened that the jury cannot now rule on your guilt or innocence. So let's see the next question. And this was a really good website, especially if you are ever called to sit on a jury, because they basically, talk about being a juror and, understanding the process. Because you think about it, you go and you sit on a jury and they're giving you all this legal jargon. And, even take Mr. Kelly's Eastern District of New York case where the jury instructions were written where there was no possible way that the jury could find him not guilty, right? And so you're sitting there trying to understand this stuff and you really don't know because you don't have a law degree. And so this website is a good website to kind of understand exactly what's going on. So in the next question, it says, isn't prosecuting someone twice or more for the same offense in the same court putting them in double jeopardy? And so the answer is, in a criminal trial, when jeopardy attaches, that does not by itself preclude another trial for the same offense. After jeopardy attaches and before that same state of jeopardy terminates, the accused can be said to be in continuing jeopardy. During this phase of jeopardy, another trial is not considered in the American legal system to be a second, separate state of jeopardy, but rather a continuation of the initial jeopardy the accused was placed in during the first trial. So when a mistrial is declared due to a hung jury, jeopardy does not automatically terminate in United States courts. Therefore, the prosecution may decide to try the case all over again from the beginning without this being considered double jeopardy. Another problem that may result in a mistrial is a prosecutorial misconduct. When prosecutors commit illegal acts during a trial or fail to act in ways that are legally required of them, such behavior may result in a mistrial. For instance, if a prosecution misstates the law to the jury, withholds evidence that would have been beneficial to the defense, knowingly uses perjured testimony, or otherwise violates the law, the judge may declare a mistrial. Why then does the prosecution, the side that was responsible for the mistrial, get another chance? Although this may seem unfair, the logic here is that the defense is the side that makes the request for a mistrial and therefore waives its protection against double jeopardy in this instance by the request. These are just a couple examples of the issues that may be in play when you see someone being tried again for the same offense in the same court. And then let's go back to the previous question where they were talking about the hung jury. Okay, does my website don't want to go back to the previous page? Okay, there it is. Because, after reading that, like, you can be retried. In most cases, they don't retry a person when there's a hung jury because they feel like it's a waste of time unless they really, really want the person. And so I think I misunderstood. So let me read this paragraph again. So it says, when jeopardy terminates in a legal proceeding depends upon how that proceeding unfolds. Okay, so I think what they're saying here, it says in some cases of mistrial, but not a mistrial due to hung jury. Okay, that's right, because with the hung jury, they do have the option to retry you. But I think once they say that they're not going to retry you, I don't think they can come back later and then say, oh, we changed our mind, we are going to retry you. I think once they make that decision, then it's a done deal. Okay. So I just want to clarify that. And let's see. I think there's a couple of more questions here. So then the next question, doesn't prosecuting someone in federal court for an offense they were acquitted of in state court violate double jeopardy? And so this is where Mr. Kelly's case comes into play, because we know he was found not guilty in 2008 in a state case in Cook County. And so now he's being brought up again on federal charges for those same allegations in the Northern District of Illinois. And so, according to this website, it says, under a doctrine known as the separate sovereigns doctrine of the dual sovereignty doctrine, two separate government entities successively prosecuting someone for the same offense is said not to violate the prohibition on double jeopardy. While this doctrine has stood for quite some time, it is still an area of ongoing dispute and litigation. A key area of dispute is who the so-called sovereigns are. In the case of Gamble versus United States, which was heard as early as, or as recent as 2019, the United States Supreme Court upheld the separate sovereigns doctrine on a 7-2 split. The majority treated the federal government and each of the state governments as individual separate sovereigns. Both the dissenting opinions from Neil Gorsuch and Ruth Bader Ginsburg point out that this understanding is in error. As Gorsuch and Ginsburg point out, in the United States, all these government bodies fall under a single sovereign, which is the people. Hence, federal and state governments are not separate sovereigns, but rather entities empowered by the sovereign. The foundation's separate sovereigns doctrine in American jurisprudence traced back more than 150 years. The United States Supreme Court laid the groundwork for upholding the separate sovereigns doctrine in the case of Fox versus Ohio from 1847. It ruled in this case that both the government and state governments had jurisdiction over offenses against the current coin of the United States, and both could punish violators. Soon thereafter, it affirmed this general concept of dual sovereignty in United States versus Marigold from 1850 and Moore versus People from 1852. Later in the Prohibition era case of United States versus Lanza from 1922, the court explicitly ruled that when the same act is an offense against both state and federal governments, its prosecution and punishment by the latter after prosecution and punishment by the former is not double jeopardy within the Fifth Amendment. It upheld the precedent in the subsequent case of Herbert versus Louisiana from 1926. In Abbott versus United States 1959 and Bartkus versus Illinois in 1959, the court upheld the doctrine both when the defendant was convicted in the court of one of the sovereigns and re-prosecuted by the other, and when the defendant was acquitted in the court of one of the sovereigns and re-prosecuted by the other. At this point, the doctrine was well established when the two sovereigns in question were the federal government and a state government. In the case of Wheeler versus United States from 1978, the court refused to limit dual sovereignty to successive state and federal prosecutions only. Instead, it held that the double jeopardy clause does not bar prosecution of a Native American tribe member in a federal court after having been convicted in a tribal court or a lesser included offense arising out of same incidents. And the ruling that just came down yesterday has something to do with Native Americans, and I am going to read an article about that when I finish this. So the Supreme Court in Heath versus Alabama 1985 once again upheld the dual sovereignty doctrine, explicitly rejecting the suggestion that the dual sovereignty doctrine be overruled and replaced with a balancing of interests approach. It further applied the dual sovereignty doctrine to successive prosecutions by two states for the same conduct. Its ill-advised decision in Gamble versus United States from 2019 means that this principle will continue in practice for the foreseeable future. So, to answer your question, is it double jeopardy that the federal government is now charging him with the same videotape from 2008? Is not double jeopardy because they're separate sovereignties. And then also, even if it was double jeopardy, it would only apply to the first videotape. And we know that in the current case that's about to start on August 1st, they claim to have 3 additional tapes. So technically they could drop the first tape that was from 2008 and still charge him with the 3 additional tapes. And then I believe in one of the future questions that was asked, they are going to talk about that a little more. Might be this next one here. Okay, so what does double jeopardy have to do with jury nullification? So the prohibition against double jeopardy is one of the features of our legal system that puts teeth in a jury's verdict of not guilty. Law professor James Joseph Dwan note in his paper Jury Nullification, the Top Secret Constitutional Right, that the roots of nullification also run deep into the double jeopardy clause. Even where the jury's verdict of not guilty seems indefensible, that clause prevents the state from pursuing even the limited remedy of a new trial. This rule, by design, gives juries the power to err upon the side of mercy by entering an unassailable but unreasonable verdict of not guilty. Jackson versus Virginia, and that was a case from an opinion from a case in 1979. So because a person who has been acquitted by a jury of one or more charges cannot be retried on those charges for the same instance or offense, a jury has the final say, even if their not guilty verdict was a conscientious acquittal by jury nullification. Without the prohibition against double jeopardy, the government could simply retry acquittals anytime it disagreed with the jury's decision. This would likely be particularly attractive to prosecutors in cases where jurors chose to conscientiously acquit the defendant by exercising their right of jury nullification. So basically, those juries in the Eastern District of New York could have been like, this don't make no kind of sense. Y'all ain't showed us no proof that any of this stuff actually happened, and disregarded those instructions that were worded in a way that they could only come up with a guilty verdict. They could have just said, we found him not guilty because this don't make no sense. Okay, so we're going to go on to the next question. The next question, where is the right to a speedy trial guaranteed? So speedy trial was something else that has come up. And so it says the right to a speedy trial is explicitly guaranteed in the Sixth Amendment to the United States Constitution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for the defense. Additionally, in its unanimous opinion in Crawford versus North Carolina, which was heard in 1967, the United States Supreme Court held that the Due Process Clause of the 14th Amendment applies the Speedy Trial Clause of the 6th Amendment to the states by indefinitely postponing prosecution on the indictment over petitioner's objection and without stated justification. The state denied petitioner the right to a speedy trial guaranteed him by the 6th and 14th Amendments of the federal Constitution. So I guess technically Darryl McDavid can say he was denied the right to a speedy trial and get himself out of trouble. Okay, so what is a speedy trial? And actually, I thought in the double jeopardy portion, they talked about auto theft, and it was like they gave some examples, but that doesn't seem to be here anymore on how double jeopardy can and cannot work. But the gist of what I was telling you guys is that unless there's some unique issue with the Northern District of Illinois charging him with that, from the same things with the 2008 case, there is no double jeopardy between the state and the federal government. Now, what might be double jeopardy is if the Cook County case is also pending, if they decide to move forward, which I don't think they are going to, if they decide to move forward, then yeah, you can raise double jeopardy because Cook County has already charged him for that tape. And there was a part on this website where they talked about car thefts and multiple cars being stolen, and I thought that applied to like the whole videotape thing, but I'm not seeing it now. But since we're in the speedy trial portion of this, let me read this and then I'll go back and look for the part about the car theft. What is a speedy trial? Under the United States Constitution, the accused in all criminal cases has the right to a speedy trial. The general concept is easy enough to understand, but the particular details of what this means can be difficult to pin down. In general, the speedy trial guarantee means that the accused must be brought to trial or released within a reasonable amount of time. The government is not legally permitted to lock people up indefinitely without trying them. What specifically constitutes a reasonable time frame is a matter of debate, litigation, and legislation. There is not just a simple, firm time limit for what is considered reasonable, and then anything after that is considered unreasonable. Rather, the current legal framework for what constitutes a speedy trial consists of precedent set by the Supreme Court as well as statutory, federal, and state law. In Barker versus Wingo from 1972, the United States Supreme Court held that under the Constitution, a defendant's constitutional right to a speedy trial cannot be established by any inflexible rule, but can be determined only on an ad hoc balancing basis in which the conduct of the prosecution and that of the defendant are weighed. With that opinion, the court established a four-part test in which courts are left to assess this right on a case-by-case basis, weighing the length of the delay, the reason for the delay, whether or not the defendant asserted their right to a speedy trial, and prejudice to the defendant. This leaves the situation quite nebulous. Lord Jesus. This leaves the situation quite nebulous and is particularly unsatisfying to people whose understanding of rights is that they are not something that ought to be left to the whims of the government officials to determine as they like. However, the Supreme Court provides only a baseline for determining speedy trial violations, with federal and state legislators allowed to provide additional protections above it. Indeed, there are additional boundaries to the concept of a speedy trial in federal and state laws. With respect to federal trials, the Speedy Trial Act provides additional definition in Title 18 United States Code Section 3161 generally allows 30 days from the time someone is arrested or served with a summons for their arrest for the federal government to charge them with a crime, and if they plead not guilty, an additional 70 days beyond that or beyond the date that the defendant has appeared before a judicial officer of the court in which such charge is pending, whichever is later, for a trial against them to commence. It further specifies extensive details applying to other scenarios. Circumstances will allow for permissible modifications of these time limits in this scenario and more. Additionally, many states impose similar numerically defined limits on various stages of the process from arrest to trial, as well as details such as what time does and does not count toward those limits, etc. To learn more about a particular state's speedy trial deadlines, visit our Jury Health Project. If you do not see your state's data, check back again, as we are adding more data, blah, blah, blah. So basically, I always thought that it was like a set number of days where a person, you have to bring a person to trial. But I guess there is a lot of things that they can introduce to delay the trial, as we saw, with Mr. Kelly sitting in jail for over 2 years before his first trial took place. And now they want to do the whole, speedy trial now with the Northern District of Illinois, because we know that Jennifer Bongine asked for more time and it was denied. And she was only asking for them to delay the trial until November 1st so she could get up to speed, because she is also in California with the Bill Cosby case that I thought was supposed to go to the jury on Tuesday. But here it is. It has not yet gone to trial. Okay, so I'm going back now to try and find where they were talking about the car theft, but I don't see it. See if I skipped over a page or something, because they were giving examples about a person being arrested for stealing a car. Okay. Maybe I was reading that on another website. But I mean, at the end of the day, the point of doing this video was to show, a lot of people are always saying, well, it's double jeopardy for them to try him again in federal court for the state court situation. And basically that is not the case, and there would have to be some extenuating circumstances that would allow that to take place. Okay, so I'm all the way back to the first question. What is double jeopardy? And I don't see that part about the car. So the example that they were using about the person stealing the car and getting arrested, and how, when and how double jeopardy would be introduced. But I don't see it. Okay, so now let's move over to this ruling that just came out about double jeopardy this week. And so this involved a guy who lived, I guess, on a reservation or something. And once again, this seems to be something that the Supreme Court remains split on. And so this is an article, Jeopardy claim by Heather Whitman runs him. I guess that's the name of her blog. I don't know what she's talking about. Or maybe she's a Native American. And that's why she got that name. But anyway, it says an intriguing divided court ruled Monday in Denezpi, Denezpi versus United States, upholding the federal court conviction of a defendant previously, go away, oh my God, close, okay, previously prosecuted and sentenced by a court of Indian offenses for charges stemming from the same incident. Justice Amy Coney Barrett wrote for the majority, joined by Chief Justice John Roberts and Justices Clarence Thomas, Stephen Breyer, and Samuel Alito, and Brett Kavanaugh. Justice Neil Gorsuch, I know that ain't how you pronounce his name, filed a dissenting opinion, joined in part by Justices Sonia Sotomayor and Elena Kagan. So the majority's ruling turned not on the source of authority of the Court of Indian Offenses, but instead approached the case by looking to the relevant text in the Fifth Amendment's double jeopardy clause. The source of authority for the laws defining the offenses in question were separate, tribal and federal. Exercises of distinct sovereigns, therefore, Merle Denezpi's federal prosecution did not violate his right not to be twice. Oh my God, y'all, what is wrong with me? Let me drink some water here. Okay. Merle Denezpi's federal prosecution did not violate his right not to be twice in jeopardy for the same offense. So once again, the Supreme Court is upholding that separate sovereignties can try you for the same thing. So in December 2017, Denezpi, a citizen of the Navajo Nation, was arrested for violent sexual offenses committed on the Ute Mountain, UTE is the word, Indian Reservation against VY, or whatever that stands for, also a citizen of the Navajo Nation. Denezpi was initially charged with 2 violations of the Code of Federal Regulations and 1 violation of the UTE Mountain UTE Tribal Code in the Court of Indian Offenses for the UTE Mountain UTE Agency. He was sentenced to 140 days in jail, time he had already served pursuant to an Alford plea in connection with the tribal code offense of assault and battery. 6 months later, a federal court indicted Denesby for a violation of a federal criminal statute pursuant to the same incident. He was ultimately convicted and sentenced to serve 30 years in prison. Denesby asserted that the subsequent federal prosecution violated his right to be free from double jeopardy, to not be prosecuted twice for the same offense by the same sovereign. The district court rejected Denesby's double jeopardy argument, and the U.S. Court of Appeals for the 10th Circuit upheld the district's ruling. Denesby's petition for certiorari, oh Lord Jesus, certiorari, certiorari, was granted by the Supreme Court on the question of whether the authority exercised by the Court of Indian Offenses of the UTE Mountain UTE Agency was an exercise of federal rather than tribal sovereignty, and thus in violation of his right to be free from double jeopardy. The Supreme Court rejected Denesby's double jeopardy argument. Rather than determining the applicability of the dual sovereignty doctrine, the court looked at the text of the double jeopardy clause, the meaning of offense, and the sovereign authority of the UTE. I don't know, is that UT? Because the TE is in lowercase. UT, I don't know. Mountain and tribe to define offenses as a matter of tribal law. Denesby's arguments focus on the basis for the initial charges brought against him in the Court of Indian Offenses and the very operation of the court itself as federal rather than tribal. Therefore, Denesby asserted his subsequent indictment and prosecution in federal court violated his Fifth Amendment right to be free from double jeopardy. Conversely, the United States asserted that the sovereignty of the Mountain tribe was a source of authority for Denesby's initial prosecution in the Court of Indian Offenses, and that because the Mountain tribe is a separate sovereign from the United States, a subsequent federal prosecution did not violate Denesby's double jeopardy rights. Citing the dual sovereignty doctrine at the outset and stating that it is not an exception to double jeopardy protections, Barrett's opinion for the majority noted a twist in the case. Rather than a straightforward analysis of two separate sovereigns enforcing provisions of their own respective laws, this case potentially involved one sovereign enforcing both its own law and the law of a different sovereign. Although Barrett framed the issue in Denesby as arguably involving one sovereign enforcer and two sovereign sources of law, the question of the ultimate source of sovereign authority for the operation of the Court of Indian Offense was not decided. Barrett's analysis turned not on who put the defendant in jeopardy, but instead on what put the defendant in jeopardy, the sovereign authority underlying the law defining the offense. So Barrett, writing for the majority, focused first on the text of the double jeopardy clause, rather than on the ultimate source of authority of the Mountain Court of Indian Offenses. She relied on the plain language of the clause, past definitions of the term offense, such as far back as 1791, and recent decisions by the court rejecting challenges to the dual sovereignty doctrine. Soundly rejecting nearly all of Denesby's arguments, Barrett urged that the language be cited from the court's case law be taken with a healthy sprinkling of salt. Barrett acknowledged that past cases such as U.S. versus Wheeler and more recently Puerto Rico versus Sanchez Vale examined similar questions, but the issues in those cases fell more squarely within the dual sovereignty doctrine. Whether the double jeopardy clause prohibits a single sovereign from prosecutions for offenses based in both its own law and the law of another sovereign was not determined by any of those prior rulings, but the court ruled separate successive prosecutions of different offenses, regardless of the prosecutorial authority exercised, cannot violate the double jeopardy clause because the constitutional protection is tied to the offense, not the prosecution. The term offense, Barrett wrote, is defined by a law and does not refer broadly to the underlying incident. The Nesby's conviction in federal court for an offense defined by a federal criminal statute, after being previously pleading to and being sentenced for an offense defined by a tribal law, although possibly prosecuted by the same sovereign, did not violate his right to be twice put in jeopardy for the same offense. Okay. Okay. Anyway, so the man done pled guilty, child, and then they done came back and got him for real. So the court cited Wheeler's acknowledgement of the inherent power of tribes to pass laws and punish violations of those laws, stemming not from the federal government, but from the tribal power of self-government. The majority, following the Wheeler court's analysis, then stated that our reasoning in Wheeler controls here. The Ut Mountain tribe, like the Navajo tribe in Wheeler, exercised its unique sovereignty authority in adopting the tribal ordinance. So basically, this man thought, okay, I'll go ahead and plead guilty under the tribal law and serve these 140 days or whatever it was that he got. But then the federal government stepped in and was like, well, that's all good and dandy, but we have the right to try you also as a separate entity. And then they ended up giving this man 30 years in prison. So in the dissent, Gorch wrote, because of Gorch's widely acknowledged experience with federal Indian law issues, the dissent's treatment of these questions, this history merits discussion, and the dissent's view of the history of the courts of Indian offenses and their current status led down a vastly different path from the analysis set forth by the majority opinion. Gorch, joined by Sotomayor and Kagan, posited at the outset that the dual sovereignty doctrine itself is inconsistent with the text and original meaning of the Constitution. From that initial pronouncement, which is consistent with the dissent in Gamble versus United States in 2019, a case in which Kagan and Sotomayor joined the majority to uphold the dual sovereignty doctrine, Gorch recounted the history of the courts of Indian offenses, noting the establishment of both the courts and the offenses they prosecute under federal regulation. He highlighted the many areas where the federal government continues to exercise authority through its administration of the courts, including its power to appoint and remove both magistrates and prosecutors, and to assimilate and approve tribal code provisions enforced by the courts. The dual sovereignty doctrine, Gorch noted, has its basis in substantive differences in the interests of two prosecuting sovereigns in punishing an act. It requires that the authority exercised cannot stem from the same source, and that dual sovereignty cannot be a sham for prosecutors trying to game the system and take multiple shots at a conviction, he argued. Amen to that. The deepest historical wellsprings of the authority exercised by courts of Indian offenses, wrote Gorsh, are in Department of Interior, a federal agency, and that authority was and remains a federal scheme. To suggest otherwise, he said, would be deeply revisionist. In Dinespy's Court of Indian Offense proceeding, federal agency officials played every meaningful role in his case: legislator, prosecutor, judge, and jailer. In other words, in the dissent's view, Dinespy's first prosecution was ultimately an exercise of the authority the Department of Interior, and the second prosecution was then initiated by the Department of Justice, making the entirety of both proceedings federal through and through. In a separate section of the dissent, not joined by Kagan and Sotomayor, Gorsh categorized the Court of Indian Offenses as a curious regime on a shaky legal foundation in the absence of any federal statutory authorization, concluding that both Dinespy did not challenge the validity. Because Dinespy did not challenge the validity of those courts, those issues remain unresolved. Courts of Indian offenses were initially established on Indian reservations to enforce federal laws and regulations that punished traditional indigenous cultural and religious practices, but were later reformed, discontinuing their paternalistic racist policies and instead providing a forum for resolution of contemporary legal cases within those same communities. The courts operate today as the judicial institutions for a number of federally recognized Indian tribes, including the Ut Mountain tribe, utilizing varying degrees of mixed tribal and federal law and personnel. Over time, many tribal governments in the United States have established new tribal judicial systems pursuant to tribal law. However, some tribes continue to utilize courts of Indian offenses to perform the judicial function on their reservations, but to the financial and human resource burdens of establishing and operating a judiciary. The outcome of the case is surely a relief to those Indian tribes that continue to depend on courts of Indian offenses as the forums in which offenses against tribal law are prosecuted. For tribes like the Ut Mountain, the ability to address public safety concerns and prosecute violent criminal offenses in a timely manner without undue disruption and delay is critical. The majority opinion took a different path than was generally expected in upholding the federal court conviction of Dinespy for horrific and violent acts. Ultimately, though, the court did not base its analysis on the decision made by the Ut Mountain and other similarly situated tribal nations to allow these courts to continue to function as the judicial institutions in their communities, a decision which constitutes an exercise of sovereignty in and of itself. However, the majority's decisive recognition of tribal law as separate and distinct from federal statutes, an exercise of tribal sovereignty and inherent power to prescribe laws that predates the arrival of Europeans on the continent, appears to demonstrate an increasing capacity from the Supreme Court to analyze questions of tribal sovereignty in a balanced and fair manner. So, I mean, based on what this case was about and the fact that they said no double jeopardy applies, then you know it's going to be hard to say that between a state, Illinois, and the federal government, the Northern District of Illinois, that double jeopardy or that double jeopardy applies would be even harder and have a higher standard and bar to cross. So just want to share that with you guys that states, the United States, the individual states are considered 50 different sovereignties, and then the federal government with their different districts are considered individual sovereignties. And so that's why you have like the Eastern District of New York being able to bring certain charges, then instead of there just being the Northern District of Illinois bringing all these charges at once, how the different states were able to break it up. And then even if they had failed, I guess other states could have, other federal districts could have came in and retried using a different method of getting a conviction, and it could have just gone on and on and on. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.